Hi, welcome back. Attorney Steve Vondran. Welcome to another exciting video. So we are talking in this video, be truthful or not. Do you know the difference between a YouTube Content ID claim and a DMCA takedown notice? Do you know the difference? Because if you're a YouTube creator, you should know the difference. They're two different things. This video is going to address that issue for you. Okay, Attorney Steve Vondran here. This is general legal information only and not legal advice. But let's take a look at it. All right, what is YouTube Content ID? Some of you probably know what that is, some of you may not, but it's essentially a YouTube software system set up for detecting potential infringement of audio, movie, TV, game clips, melodies, basically anything digital that you can put into a video could be subject to a Content ID claim. So remember, all these things are copyrighted. Somebody created them. You want to use these short clips in your videos, your fair use clips and all that. And that's what we're talking about here. YouTube, in some cases, has contractual obligations to certain companies, probably your big giant companies. I don't need to name them. And when that happens, there is no Content ID dispute. It's just a takedown, and they have a contractual obligation, and good luck. So, but aside from that, a lot of these Content ID claims are driven by, as I show here, partner programs, big YouTube, persons and companies that have lots of original content, posting lots of content, and YouTube may have entered into a partnership agreement with them for. And when they do that, they can get into this Content ID system where it will show actually in the Creator Studio. I'll show you that in a second. It'll show what the different claims are that are being made. I'll show you. Okay. Certain eligible rights holders can submit sample reference files. These are what they call sonic footprint. So the creators of the video or the news article, whatever, they can send little reference files, and that gets put into a database at YouTube. And every time a new video is uploaded, it will scan the video looking for the content of all these different partners, and they're looking for these Content ID matches. If they get a match, you'll get something like, for example, if I did something, uploaded something to my system, I might get a little something when I go in there that says a match, play match, this 30 seconds of your video matched in the Content ID system. So people may say, well, is this going to get a copyright strike? Am I going to get 3 strikes and we're going to be out of here? They're going to take down my account. What's going on? But this is why I'm doing this video. So you know the difference that between the Content ID and a DMCA takedown notice. The DMCA, both should be taken serious, but the Content ID case, that's not going to get you a copyright strike, okay? Real quick here, this is if you're looking to qualify for the Content ID. We can help your company get involved in that if you qualify. Not all people will qualify. You need to have 100% exclusive rights, the rights to show it and display it on the internet, streaming rights, those kinds of things. And you must have a substantial body of original material and content that is frequently viewed, something that people want. Some problem areas could be mashups, best of compilations, trailers, concert recordings, things where you may not own the full exclusive rights. Those things are going to be very difficult to protect, okay? Again, music rights holders must have all the rights. This means the song composition plus all aspects of sound recording. Beats, loops, and sampling can be a little bit of a problem sometimes. As I always say, try to make these your own. Try to transform those clips into something new. All right, so this is what we talk about, the play match. So I get that little play match, and it says, they saw that I used a 10-second clip of a diver diving into the water. Somehow they figured that out. Darn it. What do we do now? So the YouTube software would make a match. The rights holder would be notified, and eventually also the creator, the person that had the problem, would be notified. But I've noted here 7 different choices. So if you're that copyright holder, you essentially have 7 different choices. There may be others. One is do nothing. You could say, there can be a match and the person could just say, I don't care, whatever. Yeah, I looked at it. It's not a big deal. I don't care. Or I like how it's being used. I never really thought about that. It's being used in a really new and interesting context, which isn't going to hurt my sales, might actually help my sales. So, there's times when they may do nothing. 2, monetize the video being infringed. So if somebody could say, I'm making a claim for monetization, and they start monetizing your video. Okay, so if you dispute this, you're going to want to really make sure you're disputing this, because you could lose. I've seen clients losing a lot of money in monetization, big channels, big YouTube stars here we're talking about. And, so you need to get right on it. That's number 2. 3, they can track the stats of your video. In other words, watch how many hits you're getting, what countries are watching, those kinds of things. Watch the stats and do nothing. Just kind of wait and see, decide if they want to do something. So it's kind of a weird one, but it is an option that's out there. There's also something known as the scheduled 7-day takedown. That's where you're giving somebody 7 days to take it down, and that's, a last chance to avoid a strike in that situation. They can file the DMCA takedown notice with YouTube. That's number 5. The YouTube process, this is the big key between the Content ID and the DMCA takedown process. The Content ID, you're not going to get a strike. They're not going to take your channel down. They realize there's just a match, okay? Now, that doesn't mean that the copyright rights holder might say, I feel like suing today. You used 5 minutes of my video. It's a little too much for me. It really upsets me and my shareholders, and now we got a big problem. We want to go to court. That could be, they don't have to give you a notice. Some people will say, well, don't they have to give me a notice and a chance to fix it? No. They don't have to give you a notice to fix it. So they could file the DMCA takedown notice, just move right to that process if they want. And we'll talk about that in a minute. Or they could file a federal court lawsuit, no duty to warn, or the parties can do a workout. You can get into a license situation. So if you need help, we can help with a licensing process. So that's your play match, and that's what happens when you get a Content ID claim. Here's a look, and I got this off of the YouTube site, and this is very helpful. This is if you are in the program and you're in the Content ID program, this is what you'll see. So it will tell you, here's the top 10 destinations. Here's your video that's being monetized. It's got 7,400 views. Here it is, 868.7 thousand subscribers on this channel. And this is the channel, Vacation Destinations, and 100% of the video was a match. So you may say, wow, that's like a total match. That's like totally getting me. As opposed to going down here where you say, well, it's 30% of the video, and they only have 16,000 subscribers. So you can kind of decide, do I want this use to continue? Over here are the different actions that you can take, and here's some couple of frames from the shot. So that's what it looks like inside the rights holder inbox on your YouTube creator channel. This is in the studio. All right, potential claimants. Well, it could be anybody, but here's just some that it could be. Sony Music Entertainment, Universal Music Group, Copyright Integrity International, Aplex Software Private Limited, Fox, CNN, CBS, MSNBC, ABC, your news channels, people that are always trying to use news clips on their videos. CD Baby, here's another one. This is a company that enforces rights for musicians and artists, and they basically, help artists get paid through monetization. So you may see a claim by CD Baby. Epic Games, Electronic Arts, these are the gameplay videos where these are always unique. You want to go to the game, if you're the kind of person who wants to post the gaming clips, go to the website of the company, see what they say. They may give you specific instructions. You can use our video if you do this, or if you give us attribution, or if you're not using more than 10 minutes. So check it out. I know YouTube, last I checked anyway, has a policy that says you can use the gaming videos as long as you're broadcasting it over, basically turning off that background music, because in the games the background music is usually copyrighted, and that can trigger a problem. So gameplay videos, check into that. AdRev, that's another company that may make a claim for rights holders. So you may see AdRev for rights holder claims. These are your potential claimants, but literally could be anybody that creates compelling digital content, I would say. Third-party rights holder and fair use. Now, Content ID, the scanning system, every time they're scanning a new video, I don't have any knowledge. I've never heard that they're somehow factoring in fair use rights. So fair use rights is, I have it right here, 17 U.S.C. 104 makes it a legal right. It's a legal right to use certain content without it being deemed copyright infringement, without you having to get permission. It's your statutory legal right. So, but how rights holders and creators, they don't always view that the same way. But the fair use, because I don't think it's really being adequately reviewed, I think rights holders and everybody needs to consider fair use and in an honest way. And this is where your fair use opinion letters come in. This is where, you may need to get legal counsel involved, because there's a big deal when you have these fair use rights and somebody's going, well, I just don't want you using my stuff at all. So there's stuff. If you need counsel, this is the time to take a look. And again, in this entire process, the takedown, the counter notification, the dispute process, good faith is to me the key words. Good faith. If you are engaging in bad faith actions, that could lead to a lawsuit. I have people will ask, what is my recourse if the other party is just not recognizing fair use? And one of my main responses is that you need to really document the fair use claim. You really need to document that well. Give them another chance to put your video back up or stop monetizing on your video, whatever the case may be. But the detailed letter puts them on notice, and you may, I'll have another video on this coming up soon, the 512F action, 512F bad faith. You may have an action in federal court, maybe your only recourse, okay? What else? Lenz versus Universal. I'm going to go through this quick. You can check that out if you want. It's the Let's Go Crazy case. Basically said you got to consider fair use before you're doing these takedowns. So this is very important case from the Ninth Circuit. Lenz versus Universal Music Corp. Check that out if you want to read that. Pause the video. All right, 17 U.S.C. 107, fair use law, limitations. Here it is. If you're looking for that black letter law, you said, I want that black letter law so I know what's protected. It says right here, uses such as criticism, comment, news reporting, teaching, including multiple copies for classroom use, scholarship, or research is not an infringement of copyright. So if you're using photos or videos, music, melodies, jingles, anything, and you're using them for these purposes, you need to argue that and be thinking about that at all times, because, like I said, a rights holder may not like that you're just using it for teaching. They may not like that you're using it for criticism or comment, but that doesn't mean that they can automatically stop it. So this is the fair use law. Next page, I got the 4 fair use factors. If you're in YouTube law, you got to know these cold. These are your 4 factors before you put up any clip, any video, anything that's digital, copyrighted, something that would be copyrighted by another party. Go through these fair factors in your mind. You might want to do a check sheet and do all that and keep detailed tracking of what you think you're doing. And you can also hire a firm like ours to do that work for you. Okay, that's the fair use factors. Content ID disputes, again, will not lead to a strike or a channel takedown unless perchance the rights holder decides to convert it into a DMCA takedown notice, and that would lead to a strike. So you have to bear that in mind at all times. Bargaining power obviously is a big deal in these cases. Common claims are that the content was fair use and not an infringement. That's the main fight that we see. And one option that you have is to seek retraction from the copyright holder. So you can say, well, I'm not going to go through a more formal dispute route right now with everything else. I'm just going to see if they will retract it. And we send retraction letters out. That's one thing you can do, a friendly retraction letter. Or, like I said, file a dispute with objections, your reasons. If you're going to be disputing, have that good fair use opinion letter. any licenses that you have. One time I got a claim from a software that I use, a video software. It had a song built in, and I used the song, and it got matched on the Content ID match, and so they were monetizing my video. And I said, well, wait a second. I got this song through my software, my video creation software, and this was all represented to me that it was all licensed, that I was allowed to use it. And they dismissed their claim. Okay, so I asked for a retraction. Very simple. Again, you want to get your evidence of transformative use. That's always important if you have it. Public domain, etc., etc. What else? Content ID disputes continued. Claimant has 30 days to respond. If you make the claim, they have 30 days to respond. If they don't respond, claim expires. What are the options? When they get the dispute, the notice of the dispute, they can release the claim. Video goes back up, you get your monetization back, or they can deny it and keep the video blocked. And at that point, you would have to file an appeal. And number C, they could file a DMCA takedown notice, like I said, if they get a little huffy and puffy. Could lead to a strike. You would get a strike on your account with a takedown. Or D, they could just flip off the handle and say, I'm filing a federal copyright lawsuit. We're the bully in the town and we have all the power. So no notice is required to do that if that's an option that's out there. So you always have to be careful when you're playing in the realm of copyright law because damages can be significant. Okay, I have another video on copyright damages if you want to watch that. But again, parties can also discuss a license or trimming possibilities. And what that means is I just negotiated a deal with one of the big broadcasting studios where there was a certain length of clip that they thought was too long. There was a part of a clip that they thought went to the heart of the work. And so they didn't like it. So we ended up working out an amicable situation where the parties could live together. And that's really what you want to do. I mean, it's basically working it out. If claimant denies you, you can appeal. If your account's in good standing, you can appeal up to 3 times. And again, the difference between takedowns and content ID disputes, 40-1. Most of the disputes online, according to Google, this is according to them, not me, 40-1 content disputes over takedown. So now, moving on to the takedown notice. This is the other one, okay? DMC takedown notice can lead to a strike. 3 strikes and you're out. YouTube could cancel your account, delete all your videos, do whatever. So you got to be careful playing with strikes. It's just like a match. You can play with it, but you don't want to get burned, okay? Formal notice required. This is a formal DMCA. That stands for Digital Millennium Copyright Act. This is a formal takedown notice. So if you get one of those, a DMCA takedown notice, the process is not a dispute, it's a counter notification. So the terminology is a little bit different, but it's kind of the same thing. Counter notification puts the video back up onto YouTube, back to be monetized and whatnot. Keep in mind a few things. This is under oath. As I mentioned in the previous slide, must be in good faith. And you are consenting to local federal court jurisdiction. So that's why some people might just prefer to seek the retraction. Let's see if I can get the retraction because I don't really want to be consenting to a federal court jurisdiction. So a lot of little tactical decisions to be made in these disputes. And finally, claimant has limited time to file a lawsuit or the video goes back up. So that's how it works in the DMC takedown notice. So it's, you could put someone to a lawsuit, to a decision, and that's where you're at with that. Okay, what else? We got bad faith claims. I'm going to do a separate video on this, so make sure you're subscribing to my channel. You're going to want to know this information. I don't know who else is bringing it to you. 17 U.S.C. 512F. These are your bad faith claims under the DMCA. And as I mentioned, content ID, failure to retract, denials, those things to me should be done in good faith. DMC takedown notices, good faith. Counter notifications, good faith. When you file lawsuits, federal court lawsuits, that has to be in good faith. There has to be a good faith basis to it. And to me, 512F is the one hope for really trying to level the playing field in the area of fair use rights because it gives you an attorney fee award, it gives you damages. lost monetization claims, loss of viewer goodwill, disgorgement of the profits of the other party, those kinds of things. The one problem with it that we're having is that it requires subjective bad faith. So it means you have to show that they knew it was a bad claim, but they pursued it anyway. They knew, but they pursued it. So that's why, when we write our letters, if you need an attorney to write that letter for you, I want to know. I want to ask them, what were your fair use factors? Let me see your analysis. Here's our analysis. Let me give you another chance to put the video back up. That way you're putting it into their mind where they can see it, read it, and if you're still having problems and people say, well, what is my recourse? Look into the 512F cause of action. And again, there's not a lot of, unfortunately, fair use. You got to fight for your rights most of the time, but that's something to help. Okay. What we do, here we are. You can see what we do. Dispute resolution, fair use, YouTube disputes, that sort of thing. You got it all here. And that's about it. What else? If you need some more, you got my information here. Is a phone number, our email, and we hope you enjoyed this video. Don't be afraid to, give me a like, comments, or even better yet, subscribe, because let's be honest, you get more out of this than you do watching a political show. So subscribe to Attorney Steve channel and enjoy the information. We hope you have a great weekend. Again, general legal information only and not legal advice. I hope you enjoyed this. You now know more than the average bear on content ID disputes. Have a great day.